Hi, everybody. Welcome to my latest podcast. The title of this podcast today is Restoration, Safeguarding, Attachment and Design. The word restoration is everywhere right now. Restore Britain, restore trust, restore integrity, restore sanity. But restoration is not a slogan. It is a design question. Restore what and to what standard? If we are serious about restoration, we must examine the foundations of our institutions, including family safeguarding. The United Kingdom's Child Protection Framework under the Children Act 1989 is built on a clear principle: the welfare of the child is paramount. That principle is right. Children must be protected from genuine harm, but every safeguarding system must also withstand scrutiny. Restoration in this context means restoring confidence that our safeguarding architecture is proportionate, evidence-led, and psychologically informed. If your child discloses abuse, report it. If you fail to act, you may be accused of failing to protect. That is a clear duty. But once a concern is reported, authority transfers to statutory agencies and the court. That is necessary for investigation. However, a constitutional question arises. How do we ensure that a parent's act of reporting does not unintentionally place them at procedural disadvantage? A safeguarding system must be designed so that reporting a concern does not unintentionally disadvantage the reporting parent. That is not an accusation. It is a design question. In some cases, psychological assessments are introduced during proceedings. Psychological expertise can be valuable, but it must meet high evidential standards. Restoration means clear diagnostic thresholds, independent commissioning, transparent reasoning, judicial scrutiny that is proportionate and consistent. Psychiatric labels are medical conclusions, not litigation strategies. If they are introduced, they must withstand the same rigour as any serious allegation. That is a rule of law issue. Safeguarding is not only about preventing physical harm, it is also about preventing avoidable psychological harm. Attachment science has long recognised that children regulate emotionally through primary caregivers. Prolonged separation is not neutral. It carries developmental implications. None of this diminishes the reality that some children require removal for safety. The question is proportionality and review. When findings are later overturned or substantially revised, a further question arises. Who evaluates the psychological cost of that separation? Recent reporting by journalist Hannah Summers has highlighted a case in which findings were overturned after prolonged separation. I will include a link to that reporting in the description box. When decisions of that magnitude are reversed, it is reasonable to ask what mechanisms exist to review, process and support the child involved. In addition, academic research published by the University of Manchester in 2024 examined how child sexual abuse allegations are investigated within England's private family courts. That research forms part of an ongoing scholarly analysis of evidential standards, judicial reasoning, and investigative practice in cases involving serious safeguarding concerns. When peer-reviewed academic work scrutinises the handling of abuse allegations in private proceedings, it signals that this is not merely anecdotal debate. I'm going to have a little drink. I hope you're following. It's very important, this podcast. It's probably one of the most important podcasts I've done so far. It is an area of legitimate public and academic concern. Restoration, therefore, must include ensuring that research findings are meaningfully reflected in practice, particularly where decisions carry long-term psychological consequences for children. If a system carries authority to remove, it must also carry responsibility to repair. When appellate courts overturn decisions after extended periods, it does not automatically imply systemic failure, but it does raise a legitimate governance question. Are there mechanisms to detect whether similar evidential reasoning has been applied consistently elsewhere? That is not a call for accusation. It is a call for quality assurance. In any other public system, repeated reversals would prompt review. Safeguarding should be no different. If findings change, children are often left to process that shift privately. Restoration should include structured therapeutic reintegration. I'll start that again. Structured therapeutic reintegration pathways. Independent psychological review following overturned findings. Support mechanisms to help children understand changes in legal conclusions. I hope you understand that, because it's very important. It's very important. Reintegration cannot be left to conclusion or silence. Family courts are private for good reason, to protect children, but privacy also limits public visibility into evidential reasoning. If reputations are affected publicly while proceedings remain private, a democratic tension arises. The answer is not dismantling confidentiality. It is strengthening transparency where possible and strengthening review mechanisms where necessary. If you want more explanation on this, you can send me any questions in the comments below. Restoration in this context means restoring proportionality, restoring evidential integrity, restoring attachment awareness, and restoring public confidence. Not weakening safeguarding, refining it. Not protecting parents over children, protecting children fully, including their psychological bonds wherever safely possible. Restoration is not regression. It is refinement. It is responsibility. And it begins with asking the right questions. Oh, I really love this podcast. I really like this podcast. I hope that you can see that my deep dive investigation into family courts is progressing how it should be, in the right order maybe, and in the right direction for reform. So I have a closing address. And finally, I want to say something directly. If my daughter ever watches this, this is not about conflict. It is about ensuring that when children speak, systems are designed to listen carefully and respond proportionately. Separation is painful. Confusion is painful. Silence can feel painful. No child should ever feel that their bravery disappeared into procedure. I am not doing this to fight anyone. I am doing this because safeguarding design matters, and because children deserve processes that protect both their safety and their psychological well-being. You were very brave, and bravery should always be met with care. So I jumped in the middle, in front of another podcast that I'd already prepared for today. So that is going to have to wait for another day. And I'll give you a little clue. It's called the Anti-Blueprint. But first, I've still got some work on this podcast to do, my restoration podcast. I have a little press release going out to the media because this podcast to me is very important, based on the recent reporting. I think it was the 13th of February. You can read the whole article in my description of Hannah Summers, who I've known a number of years, and she's doing great work. So, okay, thank you for listening, everybody. Can you please press the like button, please share, and please subscribe. And thank you for following me along my journey.